Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Court calls the case of People versus Manuel Henry. All right. And there has been a motion. I've received the response. Is there anything additional? Go ahead.
Your Honor, I just believe that in this call, it's very important to look at all kinds of cases. It's really vivid, for by wrongdoing, and kind of look at separate parts. At the beginning of the call, it starts off with the defendant telling her that she wants her to not testify against him. And at the beginning of the call, the victim doesn't want that and wants him to be held accountable for his actions and says things like, I didn't want to do that, but what you did was really fucked up. He says, I want you to do one thing, there's only one way to be testified here, he cannot testify against him. She responds, you should have thought of that, but I didn't do anything, not that anybody would, cause anyone to do that. She's telling him she wants to be held accountable, she's scared of him, terrified of it, about what happened. And he keeps pushing, as the conversation continues, he keeps pushing the issue, telling her, tell them that you lied or something, this shit fucked up, this shit is fucked up for real, I gotta get back to my child. And he keeps pushing and pushing throughout the conversation and blaming her for the situation. And she keeps telling him she's terrified, she wants to be held accountable. She says things like, no, like I want to put a PPO on you because I'm scared to death. I don't know what you're going to do to retaliate. Keeps pushing her and saying, what you saying and this shit could have been fucking up my case right now. With that being said, I don't need you testifying against me in this shit. You do come, tell them what you were saying was a lie. And she eventually, throughout this call, begins to break down and is in tears and finally agrees to do something about it and not testify now. Because of the continual pushing and urging this kind of did and blaming her for the situation, trying to make her feel guilty of the situation. And you can see throughout the call that he wrote her down to agree with his own opinion from the call and not come to court testify against her. It's just a very vivid portrayal in just one call of forcing and breaking her down throughout the call, not testifying.
Ms. Gaines.
I would like to start with, perhaps we can approach and look at the file to see if Your has received service that the complainant has been served with, or otherwise notified that there was in fact a hearing previously scheduled for a matter before it turned out that the person wasn't even aware or had not even been notified officially of the hearing. And so that's where I would like to start, because if there has been notice, by people of this field, I think that immediately handles and immediately addresses this situation.
Our victim advocate did reach out to the victim about the preliminary examination. The prosecuting attorney working with us on the prosecution. We don't let him send the handle the rest of this, but I do want to note specifically there's a note in our file from victim advocate Spangler that she texted the victim on April 19th about the preliminary exam. It is also routine for our office to send a notice to the officer in charge to subpoena the victim. That I did send personally that notice to my officer in charge in this case, so the victim should have been was confirmed notified at least once that she was expected to attend to the preliminary exam. Contact was made and should have gotten an additional notification from law enforcement about that expectation. So I do believe our office has done our due diligence with ensuring that the victim was notified in this case.
So starting with that, Your Honor, I would state that I do not believe that indicates due diligence. To send a text message, it is not unusual for, without, because there has been no indication of a confirmation of receipt of the text message. Without that, we don't know that it's still your phone number, if it's an error in the phone number, we do not know if that actually got to her. Second.
Well, why wouldn't that constitute due diligence? I mean, in light of the phone call, which has to be, quite frankly, in doing this for a bit, one of the most egregious of phone calls to a victim in the case. If I follow your argument to its logical extreme, what would happen is the defendant or a defendant could make a call like that. The victim, out of fear, or alleged victim out of fear, could change her phone number. The prosecutor only has one way of contacting. And then, but they send the message. They also contact law enforcement to make contact with the alleged victim in the case. And what if it's somebody that just, at that point, because of the phone call, doesn't want to be found? That doesn't go to due diligence.
Your Honor, even at this point, we have not heard anything other than that they asked law enforcement to attempt to provide some sort of notice. We have not heard that law enforcement out there, law enforcement themselves made a call, that there's any attempt at service. I think that, in fact, by not ensuring that they have actually made efforts done.
Well, you're not arguing that a subpoena is necessary. I mean, if an officer went out there and say you have that, you're not making that argument, are you?
What I was saying is that at this point, we haven't heard that even an officer has made an effort. That is what I'm saying. I'm giving examples of what of due diligence and saying that this, at this point, we're satisfied. Do have some response with regard to the phone call itself. And I know previously in the matter I had with Ms. Barroso, she provided your time to call. I do not know if that occurred before this one. Mr. Gaddy from our office was at the previous hearing. And if you have not listened to it, I do wish to go through the phone call in more detail. But I wanted to start with that, in particular, having had a case where the victim advocate left a message on voicemail, and that was it. And with that, there was more in terms of that, plus the conversation where Your Honor found that it was not, that you did not find that it was my client's fault.
Yeah, but
So I want to start with that, but I also intend to address the information in the call.
Well, go ahead and address the information. I mean, Ms. Sender went through what the call was. If you want me to hear it, you want me to hear it. But I mean, if you're talking about the cases that I think you're talking about, I mean, what's said by the defendant in this case is got to be the most egregious that I've heard. I mean, it can go anywhere from just contact, all the way up to don't show up or some harm's going to come to you if you show up. I mean, on that spectrum, this call is way on that far end of the former of what I said, the latter of what I said.
Well, I think exactly what, if you listen to what their argument was, it was exactly that you take it piece by piece as opposed to taking the whole conversation in context. And in terms of the specific, well, as one example of the specific part of the phone call that was referenced, that, I think I need to get a PPO out of me. Your Honor, that was not part of the discussion or in, with regard to the part of the discussion involving if she should appear and that part of the phone call.
What do you do with don't show up, but if you show up, then tell them you made it up? Basically, I'm paraphrasing. What do you do with that, Ms. Gaines?
Your Honor, I think the first part is that even if that was what was said, if they have not gotten in touch with her about what the date was, if this phone call was dated weeks before, that is not in terms of what is required that the action actually caused the failure for the person to.
Okay, if you're gonna go harp on that, then what I'm gonna tell them is just 2 days before the preliminary examination, subpoena her. And then I can rule on the motion right now as to the conduct. And then if she doesn't appear, all of it's satisfied on the 21st of this month. I mean, if the argument is being made that the people haven't done their due diligence, which I don't think is true, but if that's your argument that she needs to be subpoenaed, they can go through the arguments and try to subpoena it. They got 9 days to try to do that to get her here. And then if she doesn't show up, they're going to be able to proceed by forfeiture.
I would have additional arguments at that time, given the length of time since there's been any contact with her, as to whether or not it was his.
Because I had to shut off the phone.
I understand. I understand that.
I mean, that's the reason he hasn't had contact. And I can't even say that worked because.
Is there some information that you have that
I have a lot of information about a lot of things.
That is true, right? Let me ask a more pointed question. Is there information? Have you received information that there's?
Do you have phone calls from April 11th? April 11th till now. Then that means my order to restrict and revoke his privileges worked. So when you make the argument that there hasn't been any contact, it's because I had to revoke his privileges.
What you're saying. Still would want to address that if she did not hearing and was provided with the subpoena.
Address which issue?
The reason, whether or not he was the cause, his actions were the cause of her not attending. I do also though want to go back to the phone calls, that I do believe that there is a broader context to that the statements that were brought up about getting a PPO were not with regard to him having called her, and that these were, and they were not said in response to him asking that she, pardon me, to him explaining that if she did not appear, that is how the case would look. I would also add that my client's statement of that the statement that's alleged to my client allegedly made my client that he indicated that she say something different, that alleged statement, that if he said that, our position would be that he was asking her to tell the truth about what happened. And that throughout the phone call, there are references to her being disrespectful of his mother, his grandmother's home, of behavior that he indicated to her prior to her calling law enforcement, and was asking her to leave his grandmother's home was not what his grandmother or what would be found to be respected by her in that home. And so there's a lot more in the conversation than simply those statements, and that there is a fuller context as to how, as to what was being said.
Does that context change the word?
For
I mean, that's what I'm saying, Ms. Gaines. I get your argument, but I don't know how you escape the words in this instance. I mean, go ahead.
in the case law, it indicates that the wrongdoing is the use of coercion, undue influence, or pressure to silence testimony that it would include threats of harm, suggestion of further retribution. There were no threats of harm or suggestions of further retribution made during that, or any retribution made during that phone call.
Anything additional?
Your Honor, if I may, just on that one note,
Yes.
the defendant was very cognizant that this was a recorded line. So whenever we got to the point of there being a potential for a threat or coercion or something that was explicit, he said, Casey, listen, we're on a recorded line. Casey, listen, don't do that. We're on a recorded line. That's enough in the people's mind to show that there is something in the background there. And specifically, the defendant says, are you trying to keep me locked up? And the victim says, no, like I want to put a PPO on you because I'm scared to death. I don't know what you're going to do to retaliate. The defendant responds, I'm not no crazy ass dude. And she says, I didn't think so either. And he says, so Casey, look, we on recorded lines, so can you stop talking like that, please? That makes me extremely uncomfortable, because to me that says that there's something more that needs to be said, and he can't say it because it's a recorded line and he knows that we're listening. That is threatening in the way that it's not, he's not able to articulate it because he knows it's going to get him in trouble.
Anything else? Ms. Gaines, anything else?
Just this in terms of what the people just read to you of the statement. I think that how that conversation began, it did not do response to a threat or don't come to court or else this will happen, do that, which is the point I was trying to make, to deal with, and that even if asking her not to talk about something is not the same as him refraining from making.
But at points during the conversation, he makes a statement about her not showing up. He also makes a statement that if you do show up, don't tell him what you said before. Don't tell him. I mean, he's basically saying to her, if I just were to put it in colloquial, don't show up. But if you got to show up, lie.
We would say that he did not tell her to lie. That what he was telling her is to not say what she said before, which was a lie. And that
He didn't say show up, tell the truth, did he? He was giving her the story.
Your Honor, she did not tell her specific words to say about what happened, no. But I will say, he did not give her specific words about what she should say.
Court has reviewed, the pleadings court's listened to arguments on this case, and maybe this is the reason why the no contact certainly is put in place, because these particular things. As I read the comments made by the defendant in this case, one wants to give context to them. Some of them, you don't even need to have context. I mean, he's telling her what to do. I think there is explicit and implicit as well as explicit threats to her regarding her testimony in the case, regarding her appearances. He is clearly, if anything else, in the confines of this conversation. I don't know why we don't have other charges: obstructing justice, intimidating a witness. It's clear. And as I said before, this is probably one of the more egregious of cases. I'm not pretending to hear and see everything, but certainly this is egregious. So to the extent that you want to raise the issue of the due diligence on the part of the people between now and the time that the exam's set, they can do whatever they can do to try to get her here. If she's here that day, she can testify. If she's not, I am, given what I've seen at this point, allowing the people to proceed by forfeiture, and that her testimony will come in, or her hearsay statements will come in, that will be able to proceed along that fashion. All right, so the people's motion is granted. This matter will continue to preliminary examination on May 21st, 2024, 9 a.m. before me.